Good morning, guys. In relation to the discussion on rescissible contracts, specifically on the third situation, third rescissible contracts, those that are undertaken in fraud of the creditors, let's discuss badges of fraud. So, what does it mean when we talk about badges of fraud? It simply means these are signs of fraud. And this is a result of the jurisprudence in several cases already decided by the court. In the following situation, the court decided or denominated the following situations to be some sort of badges of fraud. Number one, the fact that the consideration of the conveyance is fictitious or inadequate. So let's say, for example, you owe me 100,000 and your only asset is 150,000. And I've been demanding for the payment of the 100,000, and you already know that the next step is that I will file a collection case against you in court. So before I can do that, you already sell your property. You already entered into a contract of sale purporting to sell your property to your brother-in-law. All right. So, in this case, since the price is fictitious because this is purporting to be sale and there is no actual payment of the price, so this is considered to be absolutely simulated contract. Okay. And the law said this is some sort of a contract that has some signs of fraud, or when the price or consideration is very inadequate. All right. So let's say, for example, you sell your property with a fair market value of 150,000 because you fear that the next move that I will make is to file a collection case and then attachment of the property. So you sell it. It has a fair market value of 150,000. You just sell it for 50,000 to your friend. So it's very inadequate. So the law said, well, there is what we call a sign of fraud in this case. Right? The next one, those transfers made by the debtor after the suit has been begun and while it is pending against him. So take note, guys, in our discussion, those that are undertaken in fraud of the creditors under rescissible contracts, those that are under litigation, di ba? So this is in support to that. So let's say, for example, again, I would like to reiterate, for example, I already filed a case in court for collection against you, and then I petitioned for the attachment of your property, but before the court issued the writ of attachment of your property, you already sell the property. So the court jurisprudence tells us that there is signs of fraud when the in case of transactions like this. Okay. The third one, a sale upon credit made by an insolvent debtor. So, how can you afford to sell your property in credit when you are already insolvent? Right? So, common sense will tell us that there must be something wrong or something fishy in this transaction. Why the insolvent debtor sell it on credit when he badly needed cash? Alright? The fourth one, evidence of large indebtedness or complete insolvency. So, in other words, the court's jurisprudence tells us when there is complete insolvency, there is something fishy or something wrong with the transaction. Okay. The fifth one, the transfer of all or nearly all of his property by a debtor, especially when he is insolvent or greatly embarrassed financially. Okay. So how can you, in other words, common sense will tell us, guys, how can you afford to transfer all or nearly all of your property when you are already insolvent? or greatly financially embarrassed. Okay? The sixth one is the fact that the transfer is made between father and son when there are present other of the above circumstances. In other words, when there is a pending attachment that is petitioned already by the creditor and the father transferred the property to the son for fear of the property being attached, then the jurisprudence of the court tells us that there is a signs of fraud in this case. Okay. The failure of the vendee, the last one, is that the failure of the vendee to take exclusive possession of the property. So in other words, it could have been a bogus sale. Okay? So let's say, for example, there is a pending collection and petition for attachment of the property by the court against you. And you pretend to sell your property to X. X was not able to possess the property. Then the jurisprudence of the court tells us that there is something fishy or something fraudulent in these transactions. So these are the badges or signs of fraud, guys. So you take note of those in relation to rescissible contract, particularly on the third situation, those that are undertaken in fraud of the creditors. Bye, guys.